protects you from having someone steal your intellectual effort or the fruits of your intellectual labor. And there are four main types of intellectual property. Those are patents, trademarks, copyrights, and trade secrets. And they're all just a little bit different. Patents protect inventions like machines or software coding, something like that. Trademarks identify the source of a good or service. So if you buy a coat in the store and it has a swoosh on it, you know that coat comes from Nike. That swoosh is a trademark for the Nike Corporation. Copyrights protect artistic expression, such as paintings or songs or books. And finally, trade secrets protect secrets. They protect things like customer lists, or they protect formulas, like the famous formula for Coke. Well, the first three types of intellectual property, patents, trademarks, and copyrights, are protected by registering your intellectual property with the federal government. And what you want to do is you want to go see an intellectual property attorney, and they can help you with that process. Also, you might be able to do it yourself. It takes some work to do that. And so you would want to explore that, but also perhaps want to talk to an intellectual property attorney. With the fourth category of intellectual property, which is the trade secrets, that is protected by keeping it a secret. So it's very, very important for you to keep your secret a secret, such as your trade, your lists of customers, or etc. Don't disseminate those to other people. Keep them a secret. Well, intellectual property lawsuits traditionally have been fairly complex and costly. They can often go many years and cost perhaps even over $1 million. Now, having said that, many times intellectual property cases settle early. In fact, the statistics show that over 90% of the cases settle early. And so often you don't end up spending the kind of money that you would spend when the case goes all the way to trial. In other words, these over $1 million figures. So it's important, if you have an intellectual property dispute or problem, that you talk to your attorney about your cost constraints and about the strategies that you have for enforcing intellectual property rights. Because then you can work with your attorney to work within your cost constraints and within your strategies to get the solution that you desire. Don't forget to talk to your attorney about alternative fee arrangements. One type of alternative fee arrangement is a contingent fee arrangement, which may be appropriate in certain circumstances and your litigation attorney might offer. Now, I hesitate to say that not all attorneys offer contingent fee arrangements for all cases, but some do in the appropriate case. Well, I get this question a lot, and I get it so much that I wrote a book a number of years ago called A Guide to Intellectual Property Litigation, or actually A Guide to United States Patent Litigation. If you Google that title, you will come up to Amazon.com and you're able to buy this booklet. But you can get this booklet for free by going to my firm's website, carlsoncasperks.com, and you can download it for free. Alternatively, you can go to the MSBA offices, and they have hard copies of this booklet for free that you can pick up, or you can go to the MSBA website and download a PDF copy of this booklet as well. This booklet walks you through a U.S. patent litigation from start to finish and answers almost any question that you might have about any phase of the patent litigation as it goes from the filing of the complaint all the way through to the appeal process and anything in between.